In any event, a U.S. district judge recently overruled Judge Annalisa Torres' decision in the Ripple case, which held that certain XRP sales were not constituted security offerings. Ripple's delivery of 400 million XRP from escrow stunned the neighborhood with an unusual remark. Follow me through to find out if Ripple will win in the end if an extra judge is there. Finally, if this sounds like something that would be of interest to you, watch this new video as soon as possible to discover more. In a subsequent development, Dini District Judge Judd Rakoff addressed the ruling in the XRP lawsuit is a significant setback. The judge's decision dismisses the Ripple complaint's distinction between public and institutional sales, enabling the SEC to proceed with its lawsuit against Terraform Labs and its creator, Do Kwon. John learns about Stark, who is responsible for drawing public attention to the court's verdict in the Terraform Labs case via Twitter. Former SEC lawyer Stark was discharged following Judge Rakoff's decision to dismiss the SEC action against Terraform Lab. Remember that Terraform Labs and Do Kwon's counsel had asked the judge to dismiss the SEC case. By noting the judgment in the Ripple case, the attorneys asserted that the assets in question are not securities subject to the SEC jurisdiction. However, in response, the SEC argued against agreeing with Judge Annalisa Torres' conclusions in the Ripple case and declared its intention to appeal the ruling. In his decision, Rakoff rejected issuer Terraform Labs' request for the SEC complaint to be dismissed, stating that the SEC has jurisdiction and a strong case that Tara USD, the Anchor Protocol, and Luna may have violated securities laws. He contends that because all buyers may reasonably expect to profit from the defendant's efforts, the test does not differentiate between buyers based on the popularity of their coinage. The defense was used because a Supreme Court decision that prevents regulatory agencies from going beyond their mandate was also questioned in the judge's conclusion against the SEC by some Bitcoin defendants, including Coinbase. The Bitcoin industry does not have the same economic and political clout as other regulated industries. Judge Rakoff, who dismissed the case, stated, "At this point, it should be noted that Judge Jedrzejkov is recognized as one of the most prestigious securities law jurists in the United States." The former SEC lawyer also emphasized Rakoff's reputation for taking an impartial stance. The court's decision raised some concerns from Ripple's Chief Technology Officer CTO David Schwartz, who noted that it appeared to be based more on the special feat. Schwartz stressed that the court's decision to dismiss the Ripple case appears to be based on how the two cases' facts differ from one another, rather than on a fundamental disagreement with the court's justification. He offered two interpretations of the court's ruling. The court, for example, disapproved of the Ripple judgment because it used additional standards that were not included in the Howey test, implying that the Ripple ruling may not be applied to or adopted by the court in this case. This, according to Schwartz, is the worst. The worst-case scenario for those who believe Schwartz's statements. The court rejected the idea that it should apply the Terraform Labs Ripple judgment owing to quirks in that lawsuit, rather than because the Ripple ruling directly affects Howey's concerns in this case, according to his second assessment. Regardless of the exact facts in the Ripple case that demonstrate the distinction between institutional and public transactions, the court takes those same reasons into account. May not be applicable in the Terraform Labs scenario. According to Schwartz, in light of recent events, this would be the best justification in favor of the Torres decision. For the first time since XRP closed on July 13, the price has fallen below $0.70. The asset's current price is 0.69, down 2% from the previous day, and is trading below the psychological support of $0.70. Please remember to press the notification button. Also, subscribe to our channel to be the first to learn about new XRP advancements as part of its monthly escrow execution process. Ripple has distributed XRP coins from its escrow accounts. Nevertheless, one of the 400 million XRP escrow execution operations includes a strange message that has community members wondering about its origin and who is responsible for it. The perplexing document originally gained popularity with Mr. Intuitive, a well-known member of the XRP community, who expressed shock and wonder in a recent tweet. At midnight, the message's contents. The memo was included in an escrow execution transaction tonight. The document exchanged 400 million XRP, which is presently worth 275 million USD. Even though the transactions appeared to be standard escrow transactions, they stood out. Tepid jam has become hot jam, and Senna has become lumbo. The mousetrap has been caught. Will the damaged stock and Jeremy AP's compromised Twitter account be repaired by the end of the day, and will the gathering move to an official event that will be shown on television? As an aside, what about the revolution, David? Is the secret sauce spicy or mild? Even though the entire message is open to multiple interpretations, it does make some references to events that occurred in the XRP community. The email calls attention to lawyer Jeremy Hogan's recently compromised Twitter account, which was hijacked by criminals to promote information about a phony XRP giveaway, as previously reported. The letter questions Jeremy Hogan's ability to retake the hijacked Twitter account on July 24. What temperature is the special sauce, according to Ripple's chief technology officer in the memo? Is it hot or cold? It inquires, given that the memo may have been written by a Ripple employee, that its ambiguous nature has elicited a variety of comments from the community, noting that the writing style is reminiscent of articles produced by persons who identify as Riddlers in the SERP community. The person responsible for the address used to since 2019, the escrow transaction has been involved in communications like this. A similar document was discovered in an escrow transaction involving 1 billion XRP on April 1, 2019, according to a careful inspection of the address. The XRP community is in a state of shock. Given this, it makes sense to conclude that the message was made by an XRP community member who intended to draw the community's attention. The main question of the day is now, will Ripple win because of the extra judge? Please remember to press the notification bell. Also, subscribe to our channel to be the first to learn about future XRP advancements. On behalf of Douglas, Ripple Labs has filed a notice of attendance in the dispute against the SDC. Samuel Zalkin, a former SDNI lawyer, has attorney James K. Fillon tweeted about the development yesterday, and the motion was received by the Southern District of New York. In a document submitted to the Southern District of York yesterday, Zalkin expressed interest in cooperating with one of the law firms defending Ripple Labs in the legal conflict between Beauvoir and Plimpton LP. Zalkin is well known as a litigation partner. It is vital to mention Zalkin's expertise at the legal firm of Vale and Plimpton. He studied internal governance and white-collar defenses at Cornell Law School at the University of Pennsylvania. The area of expertise of an attorney is defending both company and individual clients in matters involving statutory and criminal enforcement. Before joining Vive and Plimpton as a litigation partner counsel in SDNY, Zalkin worked as an assistant U.S. attorney, where he oversaw multiple investigations and prosecutions involving cybercrime, political corruption, securities offenses, and bribery overseas. XRP community members have expressed enthusiasm for Zalkin's wish to join Ripple's legal team in light of his unique CV, but his application to join Ripple's legal team has also raised some doubt within the XRP community. Legislation about cryptography, the writer John Deaton. Ripple's founding attorney stated unequivocally that Lisa Zornberg will be replaced by Zalkin Sorenberg, who was hired as top counsel by New York Mayor Eric Adams. As a result, there is a void in Ripple's legal staff that Zalkin is seeking to fill. The SEC implies that it intends to challenge the judge's decision. Annalise's executive decision on Ripple's application to appear on its behalf has been lodged by Zalkin. The SEC has expressed its disagreement with the judge's judgment involving Ripple sales to individual investors. In her order, Judge Torres found that Ripple's programmatic XRP exchange sales are not securities offerings. Experts believe that the SEC will dispute a rule on the sale of Ripple to private investors. Nevertheless, the parties may agree to settle the litigation. Regardless of the Secretary's ruling, Judge Sarah Netburn instructed that the parties choose 3 times for a prospective settlement meeting, as previously reported. Salkin's legal skills will help Ripple in the litigation. Thus, guys, this brings the video to a close. Please remember to like the video if you enjoyed it. Remember to click the notification bell. Also, please subscribe. I believe that sharing this video with as many people as possible helps the YouTube algorithm. As much as you can help enlighten others in the same way that you have been enlightened, spread the word. If you're a real Bitcoin enthusiast, don't miss any of our events. We'll talk about the most recent news that affects our community as a whole when we gather tomorrow.